Hello and welcome to the American Compass podcast. My name is Oren. I'm the chief economist at American Compass. And today we are not just talking tariffs, but tariff litigation. Even more exciting, as everyone following the news is likely aware, there's obviously a very high-profile lawsuit proceeding as the legality of the Trump administration's emergency tariffs has been challenged. Just on Friday, the Federal Circuit issued its decision, siding with the district court that had likewise said that the administration had exceeded its authority. And so we are headed to the Supreme Court, but not before we are headed to today's conversation with two of the leading experts who have been following, writing about this case. We have joining us on the podcast Chad Squitieri, who's a professor of law at Catholic University. He's written a very good piece for the Harvard Journal of Law and Public Policy, making the case that these tariffs are legal. And also joining us, Peter Harrell, a non-resident fellow at the Carnegie Endowment, somebody who's done a lot of work on trade and tariffs generally, was co-author of the amicus brief filed by House Democrats challenging the legality of the tariffs. And so I think really no one better to hear from on both sides of the issue, but also importantly tried to do this not exactly as a debate, but really a conversation about the nuances of it, because I think Chad would be the first to acknowledge there are some pieces of this that are definitely worthy of scrutiny, and Peter would acknowledge there are parts of this that certainly fall squarely within the president's authority. So really enjoyed talking with them both. I think it does a great job helping to make sense of what are the really core legal issues here, what is the noise, and therefore what is likely to be the focus of the debate as this reaches the Supreme Court. So hope you find that informative. Really appreciate them both joining us for the conversation. But before we get to it, of course, have to tell you about what's going on at Commonplace, and in particular want to point you to a really great essay we just ran by Daniel Bring of American Affairs, who it's actually a book review. He reviews a book on the Dartmouth versus Woodward SCOTUS case, not a recent one. It's from the 1800s, but Dartmouth was involved in litigation back then. It really underscores the way that there have always been pressing political questions about what higher education does in this country, what the role of politics and government is in shaping that. And I think he connects it really well to some of the fights we are having today around the Trump administration's actions against higher education. So please go give that a read. Of course, read everything else we have coming out at Commonplace, and enjoy this conversation with Chad Squitieri and Peter Harrell. Chad Squitieri and Peter Harrell, thank you guys both so much for joining the podcast.
Thanks for having me on.
It's great to be on.
We are very excited to do this one. A recent issue of Understanding America highlighted both of your summaries of this case. Of the argument is probably the best that readers could find. And so I think just bringing us all together to talk about it is really ideal. I think will be valuable for a lot of folks who probably pay a lot of attention to the policy dimension of this, maybe the economic dimensions of this. And then everybody knows, but also there's this legal case looming over it. But what is the legal case? What are the merits of it on each side? What are the connections, I think, importantly, of the arguments on each side to the broader legal arguments that we tend to see people in our politics taking? I think is all stuff that frankly not a lot of folks, myself included, have as firm a grasp on. You don't go through law school learning a lot about IEEPA. And so really excited to dive in. I think probably, this we won't do this as a debate. It is an exploration of the issues, but I think a great place to start would be just to hear, from each of your perspectives, what are the key issues? How should people understand what the administration has done here and why it is getting as much scrutiny as it is from the courts? So, maybe Chad, I'll start with you. Give folks a brief overview. Here's what IEEPA is and why, therefore, the president can do what he's been doing.
Yeah, absolutely. So IEEPA is a statute that gives the president a certain emergency economic authorities. And the debate regarding the statute is whether that statute gives the president the authority to impose tariffs. And I happen to think that the legal question is relatively easy. My position is that IEEPA does grant the president the authority to impose tariffs, and it perhaps might be useful for me to kind of break down that legal conclusion just very briefly from the top. So IEEPA, in the most relevant wording, empowers the president to regulate importation. Those are the important words, regulate importation. And since the time of the Constitution's framing, it's been understood that the power to regulate commerce includes the power to impose tariffs. So you might often hear in these debates that, well, tariffs must be an exercise of Congress's taxation power. And indeed, one of the courts in these disputes said that. But that's not correct. Tariffs can be an exercise of taxation power, yes, but for over 200 years, tariffs have been understood as also being an exercise of the power to regulate commerce. And that's not really a debatable point. It was recognized in the writings of James Madison, Chief Justice Marshall, Joseph Story, the Tariff Act of 1789, signed into law by George Washington on the 4th of July. Even like the pamphleteers leading up to the Revolution, we recall them saying, no taxation without representation. But the history actually shows that they conceded that, yes, no taxation, but commerce regulating tariffs, those would be permitted. So I don't think one can seriously dispute that tariffs cannot be a form of regulating commerce. And indeed, that's relevant because IEEPA grants the president the power to regulate importation. Now, kind of the nub of the legal question is, the power to regulate commerce, that is vested by the Constitution and Congress, not the president. But under existing Supreme Court case law, Congress is permitted to delegate that commerce regulating power to the president. And nearly half a century ago, a court ruled that the exact statutory phrase in IEEPA, regulate importation, court ruled that that phrase indeed delegated tariff authority to the president. I think that nearly 50-year-old decision was right, and it's disturbed by doctrines such as the major questions doctrine or the non-delegation doctrine that I think we might get into in our discussion. So that's my conclusion. I think it is relatively clear that the IEEPA statute does empower the president to impose the tariffs that are being challenged in these various litigations.
All right, great. I think that's a great overview. It also helpfully distinguishes two levels of the question, which are both what does the statute say, but then also constitutionally, what could Congress do even if it wanted to? Mm-hmm. Peter, from your perspective, are those the sort of core issues? Other ones that you would add, or at what points do you divert from where Chad is starting?
Well, I agree with Chad that it to me is a straightforward question. Though I come out on the opposite side of how this is straightforward, which I will argue in just a moment. But before I argue why I think this power to regulate does not include the power to tariff, let me just level set, because of course what we are talking about here is not all the tariffs President Trump has imposed. We are talking about the tariffs that he has imposed under EO 14257, which is a kind of trade deficit national emergency. Tariffs are reciprocal and universal tariffs, as he talks about them. It's also the tariffs imposed on China, Mexico, and Canada for fentanyl, what you might call the trafficking tariffs. But there are also a bunch of quote-unquote 232 tariffs. These are the steel and aluminum. But those are not at issue here. So I just wanted to level set for the listeners. The legal issues here are really around the portion, more than half, but a portion and not all of the tariffs in place. So I want to respond to Chad's argument in a couple of ways. So first, I very much agree with Chad. Question is, does this IEEPA power to regulate the importation of goods, does that include the power to tariff? That's the core kind of interpretive question here. It is certainly true that going back to the late 18th, early 19th century, Supreme Court has held that Congress can impose taxes not only under its constitutional taxation power, but under its constitutional regulatory power. However, I am unaware of any incident, certainly, any incidents other than this one, where Congress gave the president taxation power by delegating him a regulatory power. In every other statute, for example, where the Congress has given the president the authority clearly to raise tariffs, it has done so very directly. It has said the president may impose duties after he makes certain findings, or the president can levy excises after he makes certain findings. So you've seen going back to the kind of early 20th century when Congress started delegating tariff power to the president, did so explicitly and under its taxing power. So I think that would be odd that if Congress had given in lots of different cases a tariff power to the president explicitly, it would also have given a sort of unbounded, almost limitless tariff power to the president via this word regulate here in IEEPA. And I'd also make two further points on this. So first, on the government's theory here, and on Chad's theory, that the power to regulate includes the power to tariff. Presumably, the power to regulate, when otherwise delegated to the president, would also include the power to tax. So does the Securities Act of 1934 allow the president to impose a tax on securities trades because the SEC has the power to regulate securities trades? The various environmental regulations include the power to impose taxes related to emissions because there is a power to regulate them. And so I think that sort of this read that just, because it has a power to regulate includes the power to tax would A, lead to kind of very weird results in other contexts, and B, like against the sort of actual history of where Congress has delegated its tariff power to the president. It's just a very different context. Just in those other cases, it's done so very, very closely. Third final point on the statutory matter, IEEPA doesn't just allow does not just delegate to the president the power to regulate the importation. It also delegates the power to regulate the exportation. In fact, these is read in parallel. It's regulate ... the importation or exportation ... right? That's how it is read. Export tax is very clearly unconstitutional. Congress has no power to impose export taxes. Very clearly excluded. It may not levy a tax on the export from any state in Article 1, Section 9. So, there'd be this particularly weird reading that somehow here the power to regulate importation should be read to include a power to levy tariffs when it would be constitutionally impermissible to read the same power on the immediately succeeding word of export.
So I think that it's interesting that the first question here focuses just very squarely on, okay, does the language literally as Congress, either based on the language they used or as they intended, contemplate taxation here? I want to throw in two other issues I've seen raised in a number of contexts. Just very curious how relevant you guys see these, or are they secondary to this particular question? One is the kind of emergency dimension of this, that the trigger for being able to use this power at all is the existence of an emergency. Some folks have raised the question, well, is there an emergency here? Maybe fentanyl is an emergency, or can trade deficits actually be an emergency? Do you guys think that's sort of, yes, that's also a huge issue? That is, it's an issue, but not as big as this other one, or not really in focus at all? But maybe, Peter, get your thoughts on that first.
Yeah, so in order to invoke powers under IEEPA, under the statute, the president has to A, declare that something is a national emergency, and B, he also has to, the text suggests he has to find that not only is there a declared national emergency, he also has to find it is a unusual and extraordinary threat to the United States. That's the language of the statute. I think that if you look at the use of IEEPA, which was passed in 1977, it's been used for a whole bunch of purposes, right? It's been used for Iran sanctions and Russia sanctions. It's been used to go after sanctioned cyber criminals. It's been used to sanction drug traffickers. So there is historical practice of interpreting of a lot of deference to what a national emergency is. In fact, a lot of courts have found that the declaration of whether something is a national emergency is a political question not subject to judicial review. And it's been used very, very broadly. So I think there is and I think in particular, because we've used IEEPA against drug trafficking, to say that fentanyl is not a national emergency, I think is a hard, you could make that argument maybe with respect to Canada, because we just don't take a lot of fentanyl from Canada, but that's a harder argument to make than the statutory one. And then there is this issue that courts have found previously in the sanctions context. These declarations tend to be political questions, not subject to judicial review. And so I think there are arguments one can make here, but I think it is a harder argument to make in this case.
Chad, I suspect you agree with that. Feel free to toss in anything else on that. But then also maybe want to ask you about the role, if any, that you think the kind of foreign versus domestic context plays in this. And I think Jack Goldsmith has made the point that if you see this as a foreign affairs power, it's very different than where Peter was talking about. Would we think about this in securities regulation or environmental regulation? How much do you think that sort of plays into the issue?
Yeah, well, I agree that as far as the emergency, or the statute also requires that this action must deal with the emergency. I think those are courts will be highly deferential to the president. That those are, for example, the Emergency Act doesn't even define the term emergency. To my understanding, that suggests this is a policy decision, not a legal decision. There's no law for a court to cling on to. It's a policy decision for the president of the United States. Yes, I think that the international component is huge here, for a couple of different reasons. And this kind of gets into some of the doctrines that we might talk about, but I'll just flag, there's a thing called the major questions doctrine where courts typically say, we're not going to presume that Congress has delegated major authority. That has only applied historically in the domestic context. It is never applied in the international context. And Justice Kavanaugh recently wrote an opinion in a recent case this last term, explaining that the logical underpinnings would suggest that it should not extend to the international emergency context. So yes, I think the international context would be huge. And if I could just one point of disagreement with Peter's opening.
Yeah, go ahead.
There was a lot of references of like, does this statute grant taxation power, or it's weird to grant taxation power through the word regulation. And it's very important to be clear. Tariffs do not have to be an exercise of taxation power. It's undisputed since the founding that tariffs can be a means of regulatory power. So yes, we often think of tariffs as being a means of taxation power, but they don't have to be. So to require Congress to use a special magic word like taxation or even tariffs is putting too much of a judicial thumb on the scale against congressional power.
Yeah, so that raises, I guess, another interesting question that I think, especially for folks who are used to the policy debates versus the legal debates, are thinking about a lot. The Trump administration has obviously made a very big deal about the revenue dimension of these tariffs, going so far as to say, could they replace income taxes? These sort of, they are promoting the policy as a core element of the fiscal policy. I guess there'd be a few ways to look at that. One would be to say irrelevant to the underlying question. One would be to say, what they're saying is not necessarily relevant. If you were using these taxes to regulate, it wouldn't matter what they're saying. But then one would be to say you kind of lose that safe harbor of, foreign affairs, discretion, whatever, at the point where the thing you're doing is raising, $500 billion a year. Mm-hmm. I guess maybe start with you on this, Chad. Do you think that is sort of salient, or at the end of the day, does the court need to kind of look past the dollar amount and the rhetoric to just the actual exercise of power?
It's very important as a legal matter. So just to return to like the originalist evidence about what these powers meant at the time that the Constitution was ratified into law. At that time, it was if a tariff was used primarily to raise revenue, it was a tax. If it was primarily to protect domestic industry, it was a means of regulating commerce. Both tariffs can regulate revenue, right? You can have can raise revenue. You can have a domestic industry protecting, commerce regulating tariff that happens to raise revenue as an incident to that. But that doesn't make it a taxation exercise of taxation power. So I do think it is legally relevant. Now, how is this going to shoot out in a judicial opinion? It's going to be quite difficult for a court to determine, well, It's primarily a means of regulating revenue. And indeed, the legal evidence suggests the opposite. All of the executive orders that Peter mentioned, to my knowledge, they don't mention revenue at all, perhaps only in passing. They mention protecting domestic industry, military preparedness, things of that nature. Now, yes, is it good political sense to go out and talk about the revenue that's being raised? Sure, but that doesn't change the actual legal question as long as the tariffs are not primarily a means of regulating or primarily means of raising revenue.
Yeah, Peter, do you see the revenue piece kind of playing in, or also more a side question?
I want to come back to this. I'll get into a legal take on this. I want to come back to some of the history on this as well, because again, as I agree with Chad, like Congress has, going back to the founding, had the ability for Congress to impose tariffs under either its taxation power or its regulatory power. Congress has also, going back to at least 1806, differentiated between tariffs, which it sees as kind of a revenue tool, has seen as a revenue and an import-export tool, but is different from an embargo, which is where it kind of sees trade and national security getting mixed, right? So the U.S. enacted its first embargo in 1806 on the British and French as part of the British-French, part of the Napoleonic wars, and them impressing U.S. sailors into service. And going back to that time, you've just seen Congress act very differently when it is granting the president an authority to impose embargoes, or when it is imposing embargoes, and when it is giving the president the power to impose duties or tariffs, right? Congress has a very long history of seeing these things differently. So the question in my mind is looking at kind of the last 50 or 60 years, when we have seen Congress in many statutes give the president many different authorities to impose tariffs for national security purposes, for protecting domestic industry purposes, for dealing with trade partners that do unfair trade practices. He's given him all of these powers. And they all those powers require the president to make some factual finding. There's an unfair trade practice. There's an national security threat. And then all these statutes use words like duty and customs and excise. Did they do all of that? But then also, when they put this word regulate in IEEPA, also gave him just an unbounded power to impose tariffs with none of these procedural requirements or substantive limits that they had imposed in all these other statutes, many of which they were passing at about the same time. And I just think that leaves you with a very not plausible read of the word regulate in IEEPA as including taxation power. And I do think this is an important point, because kind of blending the legal and policy, I actually think the president could and indeed should impose a number of the tariffs he has. Not all of them. I think policy matter. They're too broad and they're too chaotic, and we can have a long debate about that. But I think there are a bunch of tariffs he could and impose. He just would have to do a lot of work about it. He'd have to invoke Section 301 of the Trade Act in 1974 and find here the ways in which these countries are, being unfair to us, or he'd have to do Section 232, which he is doing. He's now directed more than half of all of the 232 investigations since the statute was passed in 1962. He's doing a lot, but these all have procedural things. And the reason he's using IEEPA is because he wants to get out of the box of having to go through the kind of procedural requirements and substantive requirements Congress has set when they have other contexts given him the power to impose tariffs.
Well, so that was one of the things I wanted to ask you, and then Chad, I'm going to ask you exactly the flip side of this question. But I guess I'm curious, Peter, in your view, let's say that IEEPA, right after it said regulate, said, comma, including by imposition of tariffs, comma. If that's something you think, whether or not it would be wise for Congress to pass that statute, do you think Congress essentially could delegate unlimited tariffing and taxing powers to the president as an element of an emergency power? And the question just is, did they do so here? Or would you have a concern that, at some point, the power of purse, the power of taxation has to rest with Congress even though, as you pointed out, they have successfully delegated quite expansive tariff powers already.
Yeah, so this raises an important question of, as many of your listeners will have heard of this or their policy, this non-delegation doctrine.
Right.
And kind of going back a century now, the Supreme Court has just a couple of times held that, Congress can't kind of fully delegate its power to the president. And where it does delegate the power to the president, it needs to provide a quote unquote intelligible principle for guiding that exercise of power. And in these other tariff statutes, Section 122, Section 232, Section 301, it's very clear what that intelligible, there's sort of detailed fact findings that are needed and kind of parameters around how the tariffs will be imposed in response. There's very clearly a parameter. Here, the argument would be, because IEEPA is not totally without procedural standards. The president does have to find that there's a national emergency. He does have to find there's an unusual and extraordinary threat. He does have to find the action taken deals with that unusual and extraordinary threat. He has to file an annual renewal if he wants to keep these things in place beyond a year. It's not totally without standards. I think that said, I personally think, and it's kind of open questions. We don't have a lot of non-delegation case law. We might get some in this case this fall. I personally think that providing the president a tariff power that is essentially unbounded in terms of the geographic scope, could cover any country, just based on a very simple finding, unbounded by rate, he can raise it, he thinks he can raise it under IEEPA to any rate, and unbounded by product, to cover all products. I think that would violate the non-delegation. But that's a more complicated question. I don't think we need to reach that question to resolve this case.
And so, Chad, feel free to pick up on any element of what Peter's been saying, but also want to kind of pose the flip side of that question to you, which is, stipulating that in this case, Congress did mean or should be interpreted to have meant that regulation includes tariff. At what point do you get nervous? I mean, where you have an Obama administration interpreting the Clean Air Act as meaning you can set up a cap and trade system, could a Democratic administration say also this just means we can just issue a carbon tax? Is both in terms of existing statutes or what Congress could do? Do you see any, if this is on the okay side of the limit, where would you draw the line on how much what effectively is a taxing power can just be given to the president?
Yeah, well, I think it's important to recall that the IEEPA statute says regulate importation. It doesn't just say regulate. Like an EPA statute might say regulate, greenhouse gas emissions or whatever, or regulate the securities industry for the SEC. This says regulate importation, and a traditional and well-known means, going back to the founding of regulating importation, are tariffs. So I don't think any of the, it is not going to magically make the SEC and the EPA and what have you, OSHA have.
Okay, well, sorry, just to push back on that a little bit. I mean, surely, at least in principle from your economics textbook, taxing emissions is a very standard and recognizable way of regulating emissions. I mean,
I'd say the same on trading. The Securities and Exchange Act says regulate the trading of, and I think that would also imply a taxing power there.
I suppose, I guess maybe the EPA could impose additional fees. I'm pretty sure the EPA already does impose fees on unregulated entities in the name of reducing emissions. But the broader point is, I don't think by recognizing that a common means of regulating importation as tariffs is going to be some dramatic change throughout the administrative state. I'll say to Peter's point about the different statutes, IEEPA, yes, fair that the other tariff statutes require the president to jump through different procedural hoops. IEEPA is a special emergency statute. And in that special emergency statute, the president, it would be kind of nonsensical to say you must jump through the same non-emergency procedural hoops that the other statutes impose. Now, we can debate whether there is an emergency, but under the Constitution, that decision is the president's to make within the statutory confines. So that explains the difference there. As to the non-delegation doctrine, I would be shocked if the Supreme Court overruled this on non-delegation grounds. Now, I am, in my academic writing, I am a big supporter of the non-delegation doctrine, but just this term, the Supreme Court permitted a broad delegation of domestic taxation authority. And in that statute, or in that case, the Supreme Court said, the Congress doesn't have to say, put a numerical limit on how much taxes the FCC in this case can raise. It's kind of essentially up to the FCC. There's existing Supreme Court precedent that's saying that the non-delegation principle applies even less strictly, if at all, in the international context. So if the broad domestic taxation authority survived non-delegation analysis just this year, then almost certainly a broad delegation of international tariff authority would survive non-delegation analysis as well. At least it should.
Yeah, well, let me push you on that a little bit, Peter, because I think, the strongest argument that from my perspective on the challenging the legality of all this is this idea that, look, at some point you essentially, certainly without a very clear statement, you wouldn't expect to have the president just with essentially unlimited latitude to raise, in theory, he could raise $1 trillion in revenue a year if he wanted. That sort of sends up some red flags. Conversely, it seems to me that the strongest argument in favor is that, insofar as, and whether you want to think about an emergency in terms of sudden short-term crisis or just broader foreign policy challenge, insofar as you accept that, whether you agree with the Trump administration approach here, you recognize as kind of a plausible theory of the case that the United States needs to reset the international trading system. It needs to, frankly, throw its weight around a little bit and try to extract concessions out of other countries and reorient these relationships. You would, in fact, want the president to have quite enormous latitude to do so, and you would want tariffs to be the tool, in all likelihood, that he used. That is, it wouldn't, you certainly couldn't have Congress trying to be kind of engaged in these negotiations with each country. And so it does seem to me that if one accepts what the Trump administration is doing as a plausible exercise of authority in foreign affairs, this is kind of how you want it to look. And a statute like IEEPA is the sort of thing that would provide that basis. So I'm curious sort of how much of that you think is fair or not. And if that's fair conceptually, how much of the argument just comes down to kind of insisting on a clear statement rule that it has to say the word tariffs?
So I think whether or not you want the president to have a very broad authority to rewrite the international economic order and to rewrite the trading system, whether or not you want that, and also whether or not the regulate in IEEPA is pursuant to a taxation or a commerce clause power. It is undeniable that in our constitutional system, both the power to impose duties as a part of a taxation power and the power to impose duties as part of regulating commerce between nations, they are both 100% an Article 1 congressional power. So you might want the president to have this. You also have to accept in our constitutional system, did Congress actually give him this power to do it? And I think here, the answer is sort of both a matter of history, the history of IEEPA, these other statutes that Congress has passed on the trade powers. They did not, in fact, do so. So it's almost, from a legal perspective, immaterial to me whether I want him to have this power. I might also want him to have the power to simply detain all the gang members in the country without having to go to court ever. I might want him to have that power to deal with crime, but he, in fact, just doesn't as a constitutional matter.
Well, we would also say that the Constitution would, I mean, at that level, there's also a constitutional question that would come into play. That seems
there's
like
a constitutional question here. It's a congressional authority. They have to give it to him, right? Congress has to give him this authority. So I think that if it is in fact such an important issue, and I do think it's important to have a different approach to international trade, I think he's either got to use the statutes where Congress clearly did give him the power, or he's got to go to Congress and sort of suck it up and pitch Congress on doing more here. So just as a matter of the way in which the framers, again, whether it's a power to tax is a power to regulate, or a power to tax is a power to tax. They're both Congresses.
Yeah. All right. Well, so I want to wrap up on every law student's favorite layer of the debate, which is, of course, standard of review. And we've sort of touched on this a little bit, where major question doctrine comes into all of this to some extent is it raises the question of kind of how closely is the court really going to scrutinize what the administration says its power is. There are also obviously lots of interesting questions floating around of how much deference do courts give to executive interpretations of all sorts of things. This was the debate in the Chevron context, where the court has now changed course very recently. So I guess I'm curious to what extent, and I actually have no idea, you guys would at least agree on, well, here's the level at which the court is supposed to be looking at that, or whether that is itself something that is significantly in dispute in the case. So maybe Chad, what is the actual question the court is trying to answer in some respect?
Yeah, so I think this might be teeing up a recent change that some of your listeners have listened to about the demise of Chevron deference. And under that doctrine, courts would typically defer to the legal decision of the executive branch. In a case called Loper Bright, maybe 2 years ago now, the court said no more deference on legal questions. Courts must interpret the legal questions themselves. If we were still in the Chevron world and Chevron applied here, it would essentially be game over. The president would absolutely win. There's no Chevron deference anymore, so the court just must have to determine best reading of the statute in my own judicial, acting as the court judicial mind. Does the president have the power or not?
And actually, have one clarifying question there is Chevron would have sort of, it certainly applies to kind of a notice and comment rulemaking and agency. Is it the same question when it's just the president issuing executive order, or does that typically, does that change things also?
You're right that the normal situation is notice and comment. Part of the reason that Chevron was demised is that there was the Supreme Court had so many rules and carve-outs and different ways, and it was hard to keep track of. I don't recall precisely about like an executive order in the international context. But the broader point here, I think, is that the administration is not relying on that sort of deference here. It's just saying this is the best reading of the statute. Now, some of your listeners might notice, well, what about the emergency declaration? Aren't courts going to be very deferential to the emergency declaration on the president? Yes, correct, but that is a factual question. Does an emergency exist in the world? It's not a legal question, and Loper Bright and Chevron was only about the legal questions.
Interesting. Peter, so you nodding. Is that generally your view of it also?
That is generally my view of it. I'd note that when I went to the Federal Circuit to watch the hearing, Brett Shumate, who's the Assistant Attorney General who was representing the government there, he made this point. He basically said, look, the government concedes that it is the court's job to interpret what is encompassed by the word regulate. Yeah, it's a question of law, court's job. On the other questions, what is a national emergency? Those are political questions that the court should not review. So the government kind of conceded that interpreting this word regulate, Chevron world, that's a classic judicial question of law. The only thing I'd add to Chad's comment is it was interesting. Last year, we did see the Fifth Circuit begin to address IEEPA in a post-Chevron world. So there was a case last year brought against use of IEEPA sanctions against a cryptocurrency mixer. And the Fifth Circuit held that the word property, because what the president is allowed to regulate the import and export of is property. That's another word in IEEPA. And the Fifth Circuit held, sort of post-Chevron, property did not include self-executing contracts on the blockchain. Like, it just wasn't encompassed by the definition of property in the court's view. So we are already seeing courts looking at IEEPA post-Chevron as like their job's to interpret what these words mean.
Interesting. All right. Well, last question for you guys both. I think one thing that's really interesting about this dynamic, and it's something we see more of in the Trump administration generally, is that a lot of the kind of conventional positions you expect to hear, the right of center making versus the left of center making, get somewhat reverse. That is, you have typically had, and there have, of course, in plenty of ways, Republican administrations wanted to expand the definition of various statutes as well. But certainly within the legal community, it has generally been more the left of center that has tried to argue for quite expansive executive power, quite expansive delegation. Of course, if it says regulate, that means we can do whatever we want. And it has generally been the conservative legal establishment that has tried to make the case that, actually, let's bring back non-delegation doctrine. Let's really try to constrain executive power in various ways and so forth. To some extent, of course, it is easy to say, well, but every case is just on the merits of the case, and we're just talking about the specific language here. But I do think, particularly as you sort of imagine the precedent that this will set in either direction, both in the courts and even more so in our politics, there is this is a very high profile political and economic matter, more so in many ways than a legal one. So I guess I'm partly just curious, does that concern you? Do you see that playing into the case, into the arguments? At the end of the day, judges do have to consider, what are the policy implications of thinking one way or another about this? Peter, I think I saw you, Todd Tucker from the Roosevelt Institute had said a little about this, and I saw you responded to him on the point. So I'm curious if you think that's sort of a legitimate but lesser concern, if it actually, you think this fits exactly with where, legal things should be going broadly. How does that fit in, if at all?
Well, so I think it is a really important question. And I do think that the court upholds these tariffs on the grounds that regulate encompasses this. You are down the road quite likely to see things like CBAMs, carbon border adjustment carbon taxes at the border, under a Democratic president. You might also see, various other efforts, again, not on a purely domestic basis, but on a kind of a global basis, to use this statute for a range of other kinds of purposes. And I'm troubling. I mean, I am a Democrat serving the Biden administration, but I am sort of a small c constitutionalist who believes very strongly in the separation of powers. And I think you need this kind of give and take and between the branches. And so I do think it would, I understand where Todd and where some of my progressive friends come from. If they'd like to see more executive authority down the line, because they're picturing over the longer term, it would be useful to use that. I just don't see that as how our system works. And I think it is important for our system to have the checks and balances there. But the final point I want to add, because it is important on the policy front, if the courts strike this down, as Kevin Hassett has said, as Scott Bessent has said, it's not that the Trump be able to do anything on the tariff, right? He won't be able to do quite what he has done, but he'll actually still be able to do quite a bit with some of these other statutes to take steps towards achieving important policy goals of resurrecting U.S. manufacturing. And so I think the policy, it's not like a binary thing. And the question is not all these tariffs or no tariffs. The question is all these tariffs with very few checks and balances, or make him do his homework and work to come up with a reduced, but I think still important and effective tariff regime.
Yeah. And I guess, Chad, sort of other side of it, from your perspective, I mean, the sort of CBAM carbon border adjustment is a quintessential example. It's very easy to envision, a Kamala Harris administration right now in the midst of litigation over their executive order to use IEEPA to tax carbon in some way. Presumably, virtually the entire right of center legal establishment would be aggressively litigating that point. I think, the case for what the administration has done here in part is that the actual use of the tariff power is quite squarely focused on the regulation of trade. So you could kind of make a nexus argument maybe for one thing. But I'm curious sort of how you see this particular case fitting into the broader conservative legal project that proceeds apace.
Yeah, I'll say I'm definitely concerned that this case might be decided perhaps at the lower courts, not so much on the law, but in some of these broader kind of policy concerns. I'm not sure that's really it's not the right way for a court to go about things. You're totally right that as a policy matter, I can imagine other administrations doing things that I perhaps would not like. But the answer is get Congress to amend the statute. Right now, Congress has given a special and emergency power to the president. Yes, there's other non-emergency powers that he could use, but he wants to use the emergency one because he's declared an emergency, and that just goes to the heart of, why it's important for who serves in the White House. President Trump is in the White House now, and he has this authority. So yeah, that's although I can imagine future policies that are problematic, I just don't think that should inform the legal decision. And I guess I'll flag one. You had mentioned that traditionally conservatives had been on the opposite side of like perhaps expansive power here, and I think part of what is motivating your observation there, which I agree with, is that we're usually talking about administrative agencies, and there had for some time been this legal fiction that administrative agencies were not, part of the executive branch. So it was seen as empowering unaccountable bureaucrats with authority rather than the president of the United States. The Supreme Court is in the process of correcting that misunderstanding. And I think that's, now that this is so clearly a presidential power rather than some, random bureaucratic power, I think that explains some of the difference that you're observing as well.
Yeah. Well, I think this is a terrific place to leave it because I'm struck by in both your answers, you sort of you highlight that the narrow legal question here in many ways is a narrow legal question. I mean, to Peter's point, there are many other tariff authorities out there. Chad, to your point, Congress can act. American Compass has been begging Congress to act on establishing, certainly with respect to China, certainly with respect to if we want to have a global minimum tariff, those things should be legislated. And then ultimately there's the political check on all of it, that who is in the White House is part of the way we decide what does and does not happen as well. I guess we'll leave it there, but may have to check back in with you as this makes its way through the courts. We'll have, you guys both have done such great writing on this. We'll have that in the show notes for people who want to dive in further. But Peter, Chad, thank you so much for this conversation.
Thanks so much.
Yeah, thank you. This has been great.
And we will be back again soon with another episode of the American Compass podcast.